Hi everyone, and welcome back to the Alma Line North Carolina Redistricting Leadership Program. So today we are going to be looking at the redistricting cases that happened between 2011 and 2018. Right, so we'll walk through why the cases are important overall, and then we'll give you a little bit of the history of the cases themselves. We'll talk about the redraws that resulted from them, and then sort of the dynamic that was created because of the way these cases went. All right, so why are these cases important? So the cases are important to learn about because they basically show a certain stage in the evolution of gerrymandering in North Carolina. So we know that the gerrymandering that happened in 2011 was really technically sophisticated, more so than it had ever been. And we also know that it, in a lot of instances, relied a lot on racial gerrymanders to create partisan advantage for Republicans. So the quote-unquote VRA districts that we've discussed a few times before. And these cases that would challenge these maps were racial gerrymandering cases, and they were very successful, and that success basically forced a change of tactics on the behalf of people who were doing the gerrymandering when they had to redraw the maps. So basically, instead of giving up gerrymandering, it basically made the people who wanted to gerrymander very wary of doing anything that could be considered racial gerrymandering, and sort of went wholeheartedly towards partisan gerrymandering. So loudly and proudly partisan gerrymandering because they felt like that was going to be out of the reach of the federal courts. And we'll talk more about how that turned out. So the cases themselves. So there were two main successful racial gerrymandering cases brought against the 2011 districts that resulted in the redraws of both the state legislative and congressional maps in 2016 and 2017. So these cases were Cooper versus Harris and North Carolina versus Covington. And here I have like a nice graphic that Washington Post put together that kind of explains how racial gerrymandering works and how packing works, and this will be part of the PowerPoint that you will be able to use afterwards if you want to take a closer look. All right, so Cooper versus Harris. This case was originally called Harris versus McCrory because it originally was brought when McCrory was governor. He is no longer with us as governor. I think he has done something now that is maybe a little bit more in tune with his skill set. And in this case, the voters challenged both the 12th and the 1st congressional districts as unconstitutional racial gerrymanders that violated the Equal Protection Clause of the 14th Amendment. And so you can see these are the 12th and 1st congressional districts as they looked at the time that they were challenged in this case. So, if you have listened to the previous lesson about 1990s litigation, you know that Republican voters and the Republican State Party brought many racial gerrymandering challenges against the 12th district in the 1990s, and they had been successful in getting it redrawn more than once. However, when they took control of the legislature in 2011, they drew a 12th district that was really, really similar to the one that they had challenged so often in the 90s. And you can kind of see here all these versions of the district that take place from between 1992 and and the 2011 maps look really, really similar, except for like maybe that one outlier when Democrats had to redraw in 1998. But, you know, it really did not change a lot, regardless of who was in control. So what were they objecting to about these districts? So just to tell you a little bit, in the 2011 redistricting process, so the Black voting age population in District 12 was raised from where it had been in the 2001 version of the map. It was 42.31%, so about 42%, and it was brought up to 50%. And this is despite the fact that Black voters had not had any trouble electing the candidate of their choice consistently under the previous map that did not have a majority of Black voters. Similarly, the 2001 version of District 1 had 47.76 Black voting age population, while the 2011 map raised that number to 52.65%. Again, despite the fact that Black candidate had been successfully elected from their district in every election under the 2001 map, which is a map that had under 50% Black voting age population. So why is the sort of raising of the level of Black voting age population, the percentage, kind of a problem? Like, why is that something that they're challenging? So in the past lessons, we've talked a lot about VRA majority-minority districts. So we've explained before, these are districts that meet the factors of the Gingell's test that resulted from the Gingell's case. So this means there's a cohesive, sizable minority community whose votes are being diluted due to Black voting of the white population. And in that case, a district should be drawn that allows that community to elect a candidate of their choice. So, however, if we think of these only as majority-minority districts, we end up assuming that they have to have more than 50% population of a particular minority group, because that's what majority means. And that basically locks us into this number, and it kind of opens up the opportunity to pack minority voters when it's not necessary to ensure that their votes aren't diluted, to ensure that they can elect a candidate of their choice. So, minority opportunity districts. So a lot of people who work in redistricting are now calling these kinds of districts minority opportunity districts rather than majority minority districts, because a strict majority of the population does not have to be of a certain minority community in order for those voters to still elect a candidate of their choice. So this is why the previous 12th and 1st districts, despite having a below majority percentage of Black voters, could still be considered minority opportunity districts, because they were still able to elect candidates of their choice without a strict majority of Black voters. So if we center these kinds of districts by calling them minority opportunity districts around the goal of providing minority voters the opportunity to elect candidates of their choice, rather than kind of building them around this strict numerical idea of a majority, that makes us put the focus in the right place and helps more easily identify when minority voters are being unnecessarily packed. So, all right, so that was what was going on in the Cooper versus Harris case. So North Carolina versus Covington was a very, very similar case, except it was focused on the state legislative districts. And specifically, it challenged how the leadership in the state legislature had basically preemptively drawn as many districts as they possibly could with a majority Black population, and then called them VRA districts without really providing any justification for that. They didn't do a Gingell's analysis. They didn't do any other kind of analysis to prove that they were necessary under terms of the Voting Rights Act. They just called them Voting Rights Act districts without doing the work, and did that while, very intentionally packing Black voters. So basically, why the minority opportunity district concept is sort of important and something I wanted to share with you is because the state legislature is sort of using that idea of majority-minority district as an excuse to gerrymander Black voters. So they are saying, well, a majority-minority district is always justified, rather than really trying to figure out how to create opportunities for Black voters to elect a candidate of their choice. Right. So the plaintiffs in both Cooper versus Harris and North Carolina versus Covington were successful, and the courts in both cases agreed that the districts in question were racial gerrymanders, and they ordered the legislature to redraw them. The major impact of these cases was they really showed that the federal courts were willing to go after something that they saw as racial gerrymandering in a very serious way, and that they were willing to force legislatures to redraw that. And even in the case of Covington, when the legislature redrew districts in a way it did not feel was satisfactory, they were willing to appoint a special master and allow the special master to draw some of those districts. Right, so now they've been ordered to redraw. So what comes out of the redraw itself? So, again, the court was willing to overturn these racial gerrymanders, and so it forced legislators to change their tactics. So in public, the legislators who were in charge of the redraws said that they were not using any racial data in their drawing of these remedial maps. They were not going to use racial data at all. They were not going to look at it. It was not going to be part of their calculus. Now, later evidence from the Hoffler files, and Hoffler was the consultant that they hired to draw those maps when they were saying they were using a racial data, shows that that may have been a deception. It's really, really hard, I know, to see this picture, but basically this is a screenshot from Hoffler's files that show that while he was working on these maps, he had easy access to the black voting age population numbers and was probably using them. So they said in public, but at least in public, they said that they were not going to use any racial data. Now, leaving aside questions of whether or not that would allow you to actually draw the kinds of minority opportunity districts that are a good thing and that we want to happen, they said that they were only going to partisan gerrymander. They weren't going to look at race at all. All right, so they put this total emphasis on partisanship. And basically, they're operating in this situation where the courts have been really clear that they're not going to allow racial gerrymandering, but they've been really, really unclear about whether or not they're going to allow partisan gerrymandering. The courts had sort of, in some ways, had signaled that, like, maybe they thought that this was something that the federal courts could deal with, but they had never decided on a test. You know, we think of, like, the Gingell's test as these standards. They had never decided on a standard by which to evaluate partisan gerrymandering, and they never really even made a final determination as to whether or not it was a justiciable question, which basically just means the federal courts feel like this is an appropriate thing for the courts to deal with in the first place. So this really seemed like a safe bet to the leaders at the time, that they could just go whole hog into partisan gerrymandering because the federal courts weren't going to do anything about it. And because most Black North Carolinians vote for Democrats, gerrymandering on a partisan basis is going to have basically the same results as racial gerrymandering. I know we've said it a ton of times, I know you've heard it a lot from me, but in North Carolina, racial gerrymandering and partisan gerrymandering are not things that you can easily separate. And so by just partisan gerrymandering, you're going to have a lot of the same effects that you have when you do racial gerrymandering. And so in a way, you can create racial gerrymanders, but have less possibility that your districts will be overturned in court because you can say, maybe lying, that you only used partisan data, you did not use any racial data when you're drawing those districts. And you can see as an example here about, like, when I say that they were proud of this, they were very proud of this. You can see here David Lewis, who is the head of the House Redistricting Committee, and Ralph Heiss, who's the head of the Senate Redistricting Committee during these redraws, and still currently for the moment, wrote this kind of op-ed in The Atlantic saying, yes, we drew these maps for partisan advantage, and that was the point, and we have the right to do that, and, you know, no one get in our way, basically. All right, so after this, so this is the new normal, right? This partisan gerrymandering tack, just going wholeheartedly into partisan gerrymandering. So obviously now it's a question over whether or not the federal courts really will address partisan gerrymandering. So the other significant case that comes up in this period is called Common Cause versus Rucho. And in that case, the plaintiffs challenged the redrawn congressional maps from 2016. So Cooper versus Harris forced a redraw of the maps, and those maps were an intentional and public partisan gerrymander. And so this case was challenging that redrawn map as a partisan gerrymander. So the federal courts basically were forced to confront the question of whether or not partisan gerrymandering was constitutional. And they punted, kind of. Well, I mean, that's not fair. So a lot of the lower federal courts found that the 2016 congressional maps were an unconstitutional partisan gerrymander multiple times. And when the case went to the Supreme Court was sort of when the punting happened. And I think that this meme shows sort of maybe their reasoning, which I think is full. You know, we can't make a mistake if we don't do anything. I think that that's a very poor reasoning, especially from legal scholars, but, you know. So basically what they said in the majority opinion when this case got to the Supreme Court was partisan gerrymandering is a problem, and it has some serious impacts. But partisan gerrymandering claims present political questions beyond the reach of the federal courts. So in my opinion, basically what they're saying is it's not our problem, and please stop bringing these cases because they make us uncomfortable, because if we made a decision, we might reveal our partisan biases or go against our have to go against our partisan biases. And you remember what happened in Bush versus Gore. And if you were around for Bush versus Gore, you probably have lots of opinions about it, and so do I. And so you can see kind of what the dynamic might have been here. All right, so this is the situation we're in. You know, the movie, The Empire Strikes Back, the Star Wars movie. The legislature's gamble had paid off. They felt like, okay, now we can gerrymander with total impunity as much as we want, as long as we call it a partisan gerrymander and don't use race, we can just go ahead and do it. And yes, I know I made this little meme, and I know these are scenes from Return of the Jedi. I am also a Star Wars nerd. But you know, we're in the moment of The Empire Strikes Back, where, you know, the evil empire has resurged. So, or so they thought. You know, Star Wars, it's a hopeful story. All right, so next time we will be talking about the 2019 cases, Common Cause versus Lewis and Harper versus Lewis. These are the cases that happened just last year, and they kind of changed the game again completely. So I'm looking forward to talking to you about that, and we're also going to have some really interesting other special guests coming up soon to talk with us. Some legal experts are going to talk with us, some mapping experts are going to talk with us, so I'm really, really looking forward to it with you. All right, thanks again for listening, and I will see you all again soon, I hope.